Okay, my name is Shird T. Myrick, DC number 195078, Florida Department of Corrections. I present the case Shird T. Myrick about a blatant injustice which defies the Constitution principles and the integrity of the American justice system itself. This case, my people, involves the murder of a security guard on duty as an employee of Mayor's Jewelry Store located in Miami-Dade rich community at Coral Gables. The victim, Mr. Louis Brito, may his soul rest, was a 57-year-old Cuban immigrant. The suspects were African-American, and I was included. And with mounting pressure coming from the Cuban community, local authorities in Miami-Dade County felt the need to solve this high offense with pressure behind it. Me, the brother Shird T. Myrick, along with three of my co-defendants, were indicted by a grand jury. I was indicted for first-degree murder and armed robbery. The state of Florida seeks the death penalty against me and my co-defendants to satisfy partisan passion and private intimacy, being that Mayor's Jewelry Store is a billion-dollar industry, and private intimacy, meaning that it was racial motivated. After 4 years and 8 months, the state prosecutor, Gail Levine, along with trial judge Rienberto Diaz, who happens to be a Cuban descent, conspired to conform their views of the necessity of the case by disregarding the institution of the grand jury, where records can show an added charge being amended to my indictment on April 2nd, 2003. In details, on December 14, 2007, Judge Diaz ordered that the state had been rendered consent to add the felony of grand theft auto and to falsify such charge to become charge 3 of my indictment. In plain language, United States Supreme Court case law ex parte Bain, 1887, is well settled in ruling that once trial judge Diaz gave trial prosecutor Levine the consent to add a charge to my indictment without resubmitting the case back to a grand jury, made the 2003 indictment void, which left me unprotected of the guaranteed rights of the 5th, 6th, and 14th Amendment of the United States Constitution. Fast forward. On January the 14th, 2008, I was forced to experience a hasty, malicious, and oppressive public prosecution, whereas the trial court proceeded in want of a lawful indictment. Being that the indictment that the grand jury presented has been void because it was no longer the indictment that they presented. Nevertheless, I was convicted and sentenced to multiple life terms and 10 years on a void indictment, which makes my detention now illegal. After years of research and toil, I discovered my entitlement to be discharged according to Supreme Court rulings, Ex parte Bain and Styron, 1960. Me, Mr. Myrick, as a pro se litigant, filed a writ of habeas corpus in DeSoto County under Florida Statute Chapter 79. The Florida Judicial Court has mistreated my writ of habeas corpus outright due to my case and cause and matter not having the public in attendance, causing a miscarriage of justice. I present this case to Dateline in the world, all platforms, and all people of freedom to bring about freedom and liberty to the person, son, father, grandfather, and husband Shird T. Myrick. This case has the potential to expose judicial oppression, and with your help can bring about a cure and justified remedy to not only myself, but the likes thereof, along with the public's interest for justice. In closing, the events of the past have become examples for the present and the future. I'll be back at you to give you more.